Okay, welcome back. Let's continue with our class about the other appeals. Other appeals also means cross appeals. Crosstalk. What does that mean? Crosstalk. 相声 cross appeals. Okay. Then, what does conditional mean? Conditional means 附条件的，对吧？ We've learned in civil law 附条件的民事法律行为。How to say it? Civil conducts. We can say conditional civil conducts. 附期限的民事行为。This conditional is something like that. Then, what are the conditions for the other appeals to be valid? One, two, three, four. We've got 4 conditions for the other appeal or cross appeal to be valid. What are they? You cannot find them. You cannot find the answers in the PPT or in the teaching materials, but rather I've searched it on the internet with the assistance of AI. Okay. Now, what are the conditions? Condition number 1, listen. Condition number 1, an initial appeal must exist. It's easy. An initial appeal must exist. What's the initial appeal? This one, right? This is the initial appeal. Initial appeal must exist. Initial means the first, right? Something in the first place. Initial. For example, the initial letter of valid is V, right? The initial letter of valid is V, initial. Initial appeal must exist. Condition number 2. The proposer must be filed by the appellee. The proposer here. The proposer must be the appellee. Okay? Easy, right? Number 3. Within the specific time frame. Within the specific time frame. For example, within 2 weeks, the other appeal must be filed within 2 weeks. For example, that's the 3rd condition. The 4th one, but not the 4th one, is the last one, but not the least one, is the content of the appeal must be limited to issues of law in the panel report. issues of law in the panel report. What about factual issues? Factual issues. Can factual issues be brought up in the other appeal? No. Only issues of law in the panel report can be brought about in the other appeal. Again, what's the second condition? The key word for the second, the proposer must be the appellee in the initial appeal. Okay. The proposer must be the appellee in the initial appeal. We can call it initial appeal. 最初的上诉。Okay. That bottle is cute. Let me check. Gourd bottle. Okay, now let's continue. Then what's the legal issue in this paragraph? The legal issue in this paragraph is about what? One of the 4 conditions was not met. Listen up. One of the 4 conditions was not met. That's why the appellate body, as the condition on which the United States and Mexico premised their request was not met, the appellate body found that there was no need to address the United States and Mexico's conditional appeal. So the appellate body did not deal with the other appeal, the conditional other appeal, because one of the conditions was not met. So for this issue, it's not that complicated. Maybe 100 or 200 words is okay to describe clearly the whole issue. Okay. Now let's go on with the 4th legal issue. Do you still remember the justification proposed, put forward by China? China restricted the export of raw materials with some reasons or grounds. What's the excuse? What are the justifications put forward by China to justify its restrictions, its export restrictions? Do you remember? Yeah, to protect what? The health, the life and the health of its people or plant or animals. 保护人 植物、动物的生命和健康，是吧？ This is a very, very good justification. But where is this provision? Where can we find this content in the sources of the WTO? Actually, it's in GATT 1994, Article 20. The title is General Exceptions. That's an exception. Yes, China admits that. Yes, we violated the WTO rules. We restricted the export. Yes, I admit that. I violated the WTO rules. But I violated these rules with a good exception to protect what? The life and the health of people, of the Chinese people. This is China's position, right? Then guess what's the position of the complainants? China's restriction measures violated which WTO instrument? 1A, 1B, 1C, or some other instruments. Actually, China violated this article, paragraph 11.3 of the accession protocol. Accession protocol, what's that supposed to mean? 中国 when China tried to enter the WTO, it signed an instrument. Yes, it's called Accession Protocol of China, or China's Accession Protocol. In this protocol, additional obligations, or we say WTO plus obligations, are in this instrument, right? And in this protocol, China commits that it will not impose export duties on almost all the goods. China commits to remove all the tariffs for the exports. Of course, there are exceptions. There is an Annex 6. Those goods can be imposed tariffs, but almost the majority of the goods cannot be imposed tariffs. That's China's commitment. That's your obligations. You must follow these obligations. But you, right now, your measures of restrictions have violated this article by imposing tariffs or export quotas. Yes. Then, the complainant's position. What's the complainant's position? The complainants, the United States said, you are not allowed to invoke Article 20 of GATT 1994. You are not allowed to invoke that exception rule. And what's the position of the panel? The panel says, upheld the panel's finding. The panel says there is no basis in China's accession protocol to allow the application of Article 20 of GATT 1994 to China's obligations under this. No legal basis for you to invoke the exception rule. And the appellate body upheld the panel's finding. So China is dead on this issue. Problem solved. No legal basis. What's your opinion? Do you think China has the right to invoke this exception rule? Yes. In my opinion, yes. You know what? In this case, the panel upheld the panel's finding. But in the next case, the appellate body said China can invoke this exception rule. Similar cases, different results. Why? But exactly in that case, China still failed. Although you can invoke that article, but you are not successful to use that exception rule. Because there are a lot of requirements for you to successfully invoke this. You must meet a lot of requirements for you to justify your violations. A lot of requirements. And those requirements appeared in the final paper test of the 2022 of their WTO course last semester. That's an essay type issue. At least 20 points for you to remember. That's why it's an essay type issue. Next semester, we will talk about it in detail. Okay. What requirements are needed to successfully invoke this Article 20 of GATT 1994? 要成功的援引这个例外条款，要满足的条件非常多。第一个前提是你能不能援引它，这个地方说不能援引，但是下一个案子说可以援引，即便是可以援引，因为要满足太多的条件，中国未能满足，所以还是失败了。这些个具体的条件，足足的有20个小点，我们将在下学期的 WTO 法当中给大家详细介绍。这也是上学期22级国经期末考试的论述题，要他们用英语默写，都满了啊！但是你们放心，我们考试从来不出重题，你们没有机会再考这个了啊！但是还有别的。Okay, now let's continue with the legal issue number 5, the fifth issue, critical shortage. Critical shortage. an export prohibition or restriction in Article 11.2a is a measure applied temporarily. Article 11.2a of the GATT 1994 temporarily 临时的适用的 to prevent or relieve a critical shortage. To provide relief in extraordinary conditions, to either prevent or relieve a critical shortage, to bridge a passing need. Look here, this article, GATT 1994, Article 11.2a. This article has a name. What's the title? What's the name of this article? It's about quantitative restrictions, 数量限制条款。大意是 the general meaning is, yes, you can restrict exports, but that's only when in your own country there is a critical shortage. That means in China, we are in short of these raw materials ourselves. That's why we need to restrict the exports, right? But this kind of restriction must be temporarily applied, must be applied temporarily. It cannot be a long-term or indefinite. It must be of a limited duration instead of an indefinite period. The restriction must be of a limited duration and not indefinite. Okay. The appellate body found that the term critical shortages refers to those deficiencies or lack in quantity that are crucial and of decisive importance, or that reach a vitally important or decisive stage. Okay. Look at the last sentence on this slide. Such a restriction must be of a limited duration and not indefinite. 这个你可以进行临时的限制，数量限制嘛。这个数量限制是有期限的，必须是临时适用的，不能是无限期的。然后你再看一下申诉方和被申诉方的立场，专家组的立场，上诉机构的立场，也很简单啊。Now let's move on. As you can see, the term critical shortage refers to those deficiencies in quantity, 数量上的不足 that are crucial and of decisive importance, 至关重要的或者具有决定重要性的数量不足，或者达到了这样程度的阶段。这个问题中国也是怎么样？ Is China successful on this issue? Yes or no? What's your opinion? Is China successful on this issue? Where's the evidence? What does this mean? Refractory. You know, in American English, the Americans tend to read this suffix as tory, factory, refractory. But in British English, tory, refractory. That's the difference. Refractory grade bauxite 什么意思啊？耐火级铝土矿、矾土矿啊，耐火级是 temporarily applied。中国的出口配额是临时适用的，是吗？Appellate body upheld the panel's conclusion that China did not demonstrate that its export. So China failed on this issue. Okay, let's move on. To the last issue, the sixth one. What's this about? It's about a phrase made effective in conjunction with in Article 20G of the GATT 1994. Made effective in conjunction with. What does this word mean? What does this phrase mean? Made effective in conjunction with. In conjunction with means together. Together. Again, you still remember the reason? If China would like to export, restrict the export of raw materials, China must demonstrate that you would reduce the production, the domestic production in China. You cannot only restrict export while at the same time encourage domestic production, right? That's what does made effective in conjunction with, which means you cannot discriminate against the foreigners. 既然你想限制原材料的出口，那么你国内的生产必须也同时限制，你不能只为了限制出口而同时鼓励国内生产，给你的国内企业提供廉价的原材料，所以必须得 in conjunction with, at the same time or together, make your measures effective together. What's China's What are China's measures? Look here. The purpose of the talent measure must be to ensure the effectiveness of restrictions on domestic production and consumption. 国内的生产和消费. That's the position of the panel. But the appellate body found the panel erred. Yes, the panel made a mistake on this issue. This is the panel's position. Look here. Contrary to the panel's findings, the appellate body saw nothing in the text of Article 20G to suggest that in addition to being made effective in conjunction with restrictions on domestic production or consumption, a trade restriction must be aimed at ensuring the effectiveness of domestic restrictions. What does that mean? What's the position of the appellate body? According to the appellate body, China need only to ensure the measures aimed to restrict the production and consumption both domestically and overseas at the same time. At the same time. But look here. The effectiveness, ensuring the effectiveness. Yes. According to the appellate body, is the effectiveness required or necessary? No. No, the effectiveness is not required, is not necessary. I think most of you are lost on this issue. So I decide to explain it in Chinese. 上诉机构只是要求你的国内措施限制原材料生产和消费的国内措施和限制国外出口的那些个措施同时采取就可以了，没有要求你限制国内生产和消费的措施要达到和限制国外的那个措施一样的效果，没有说，必须说也就是说限制了你国外的出口，我也限制了国内的生产和消费，但是我国内依然还有持续的供应，没有达到像国外限制的那个级别那个一样的效果，不要求达到一样的效果，只需要你限制，同时限制就行了。所以在这个问题上，上诉机构推翻了专家组的结论。专家组认为，你想限制国外的，你想限制原材料出口，就必须同时限制国内的生产和消费，而且要达到和限制国外出口一样的效果。这是上诉机构的这是专家组的意见。但是上诉机构认为，只需要同时限制国内生产和消费就行了，不需要达到和限制出口一样的效果。Then it all comes down to one question. On this issue, is China successful or not? 在这个问题上，中国是赢了还是输了呢？好像读不出来，对吧？你读不出来，你不知道结果，所以这就有赖第二组的同学，你要把它写清楚，你把那些个背景信息给我们补充清楚，就是这个问题。我们想知道的无非就是来龙去脉、输赢、立场、依据。你把它像写一个故事一样，你给我说清楚，让大家都能看清楚就好了。那你就我有一个问题需要你回答，在这个问题上，中国到底是赢了还是输了？那个专家组报告和上诉机构报告里一定有答案。用关键词搜一下啊，实在不行用 AI 啊，我也没说不让用 AI， 但是你最后呈现出来的这个结果必须是有依据的。你的结果总是要有依据的，最好是利用了上诉机构报告或专家组报告当中的原文，你作为论据来支撑你的这个结果。你可以先用 AI 搜一下，知道是个什么样子的，然后再去相应的 locate the necessary information。I think that's the lecture for today. Now let's open it up for questions. Do you have any questions? 第8周哈，第8周我上课的时候有交上来，每个人都有交，包括中英文。中英文，这格式是这样子的哈，就是中文、英文。With the assistance of AI， 在 AI 的帮助下，先把这个大致的思路梳理一下，是吧？这个是这个法律问题缘起，谁提出了申诉，然后他是什么立场，然后被申诉方什么立场，专家组什么立场，上诉机构什么立场。在讲立场的时候，他说的什么话，要用引号把那些引起来。每个人只负责一个小问题就不多了。If there are no more questions, then let's call it a day. I'll see you next week. Goodbye for now.